Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. I'm Alicia Downey, and today's episode is Shortchanged, the Treasury Department's report on labor market competition in the United States. In July 2021, President Biden signed an executive order on promoting competition in the American economy. The executive order was remarkable in many ways, not least of which was its directive that multiple federal agencies grapple together with the kind of competition-focused questions we usually think of as under the jurisdiction of the Federal Trade Commission and the Antitrust Division of the Department of Justice. The executive order tasked the Treasury Department, in consultation with DOJ, the Department of Labor, and the FTC, to assess the state of competition in the United States labor market. In March 2022, the Treasury Department issued a report of its findings, a link to which will be posted on the webpage for this episode. Our guest today is a Treasury official who helped write that report. We look forward to hearing what he and his colleagues discovered in their investigations and why it is important for the United States to create and maintain a competitive marketplace for labor. Joining me today is my co-host, Anant Raut. Welcome, Anant.
Thank you.
Would you like to introduce our guest?
I'd be happy to do that. Our guest today is Neil Mehrotra, Deputy Assistant Secretary for Macroeconomics in the U.S. Treasury Department's Office of Economic Policy. Prior to joining the Treasury Department, Neil was a senior economist at the Federal Reserve Bank of New York. Neil is a graduate of Princeton University and received his PhD in economics from Columbia University. Welcome to the podcast, Neil.
Thanks. It's great to be here.
So, why was this report published?
So this report comes out of a executive order that the president issued in mid 2021, and the president has been very focused on making sure that our markets work both for consumers and for workers. And so as part of that executive order, it was an executive order on competition, the president instructed Treasury in consultation with the Department of Justice, with the Department of Labor, and the FTC to look at labor markets and examine labor market competition and what impact declining labor market competition may have on wages and employment. So we were given that task and we wrote this report to investigate the state of labor market competition.
And just for a little inside color for our listeners. So 5 years ago, I was in the Obama administration's Antitrust Division. We worked very closely at that time with then Vice President Biden's office. A couple of folks in there, Ben Harris, Tushar Seth. The vice president, now president, was very interested in real wage growth for low and middle income workers. And we were kicking around a lot of ideas at the time about competition, what antitrust could do to stimulate competition in this area, ideas that are now squarely in the progressive camp, but were a little ahead of their time. And we'll get into some of that more later. But I was blown away to see some of these ideas resurface now in the Biden administration. For people in the labor competition space, I would go so far as to say this is almost a bombshell report in terms of some of its findings. So, Neil, what are your top three takeaways?
Yeah, so I think our key findings from the report was that, workers, from the set of credible studies that we're looking at, workers are losing about 20% of their wages due to insufficient labor market competition. And another important finding from the report is that a lot of low-income workers are subject to various restrictions, be it occupational licensing or restrictive employment agreements that inhibit their ability to search for jobs and to, make sure that their wages are keeping up with what they're producing. And then I think a third finding from the report is the discussion around around antitrust and how the Department of Justice and Federal Trade Commission are thinking about the importance of antitrust for labor markets. And so there's an important discussion, I think, in the paper about how their thinking has changed on this.
Thank you. Let's go over each of these key takeaways in turn, starting with the first one, that workers are losing as much as 20% of their wages. Tell me about the methodology. What is causing this?
So, I mean, there are a variety of reasons why workers may earn less than what they produce. Just stepping back for a second, in a perfectly competitive labor market, we would expect workers to earn what's called their marginal revenue product. So exactly what, a worker should be, in a perfectly competitive market, a worker is earning what they produce. And we know that in the real world, what workers earn is not always tied to what they produce. And that can be because firms have some degree of power relative to their workers. And this can happen because they're the dominant employer in a given region. So you can think about like a small town where there's a single major employer and where they're able to push down wages. But workers firms are often able to exert power relative to workers, even in settings where there's not just a single firm that they're facing. So the way we think about labor markets is that there are firms and workers. Firms are searching for workers. Workers are searching for jobs. They meet and then they bargain over wages. And in that bargaining process, if there's asymmetries in terms of information, if there's other types of frictions in that search and matching process, that's an avenue through which firms can pay workers less than what they produce. So I mean, in the paper we discuss we discuss a set of findings, various methodologies that labor economists use to try and assess the degree to which wages differ from what the perfectly competitive wage might be. And those estimates come in the range of 15 to 25%, that workers are getting paid 15 to 25% less than they would than what they're producing.
And this is where I think the report moves forward the debate that we've been seeing the last couple of years within the antitrust bar. You have some folks saying labor market power doesn't exist. You have some folks saying that it does exist. Your report seems to say affirmatively that yes, it does exist, but the reasons, I think, are what is interesting here, because when skeptics hear this, they'll say, "Oh, come on! This idea that you have a one company town in classic monopsony power, that's not the reality most people face, and that's not what you're saying is happening. You're attributing it not to classic demand side, monopsony power, but in large part, if I'm understanding it correctly, to frictions in like the search and matching model that you think might better explain what's going on in the real world."
Yeah, I think you're exactly right when you're saying that, most labor markets in the U.S. are not sort of a company town. They're not characterized by the classical monopsony framework where there's a single employer that is able to exert power over a set of workers. What the economics literature is sort of increasingly investigating is that some degree of labor market power may be intrinsic to the employer-employee relationship. And like you said, frictions between frictions to searching for new jobs, frictions that are sometimes imposed by the employer, things like restrictive employment agreements, frictions that are some kind of inherent, where a large employer might know much more about prevailing wages than the employee might know. Those types of frictions are what are the way in which labor market power is manifested, and the way in which wages can sometimes not keep up with what workers are producing.
So there are really two things going on here, because I know that there will be some folks hearing this who are thinking, well, I mean, if you're saying that every employer has some sort of monopsony power over all of their employees, this sort of sends us down into a spiral where every employer is monopsonist. So then do you break up every single, but that's not what we're talking about here. You're talking about two things that I want to discuss separately. One is some inherent power, market power that an employer has over their employees, but then also practices that employers have adopted that make it more difficult through this asymmetrical bargaining power. So maybe starting on the first part, because this is what cuts against some of the classic theory of how low wage labor markets should work. There's just this assumption under classic theory, if I'm correct, that low wage workers can just skip effortlessly from one job to another job for a few percentages increase. There's nothing holding them back. What are some of these inherent imbalances that you have found in the employer-employee relationship?
So, theory suggests that there's a lot of different ways in which firms are, perhaps at an advantage relative to workers. As I mentioned before, firms, particularly larger firms, may have a better sense of, they may be at an informational advantage relative to workers. They have a better sense of what wages are, both within the company and wages within a particular market. There's also advantages in terms of something that you might term as liquidity constraints, like workers don't have a infinite horizon over which to search. Right? They can search is costly. They face unemployment if they continue to search, and they may have limited resources to be able to search for a long period of time for precisely the right type of job. So, and then you have the practices that employers may engage in that restrict search or restrict the ability to move to a potentially better job. So the restrictive employment agreements that we talked about, like non-compete agreements or other types of being subject to an occupational license that doesn't allow you to necessarily easily move across states. So I think that those are the types of frictions that we're talking about, that even for employers that may not be terribly large, that they're still able to exert some degree of market power relative to their employees.
And that was an interesting insight that was almost slipped into part of the report as an afterthought. But I thought that was really interesting, where you're saying that the size of a firm may not necessarily correlate to their actual market power. And so using that as a proxy may lead you to incorrect conclusions about their actual market power. But so let me just go back to the first half of what you were just saying and try to put it in real world terms for people who are listening. So, classic theory is that, this merger or this transaction isn't really going to increase market power because workers can just move here or there. But what you're saying is, look, there are other factors that may make people stay in a job or not get paid their full wage. Maybe this is the cost of moving. It's the mortgages. It's the schools that they have. There are, they've been working the same job. They have the shifts that they want. There are these factors that may make them deviate from what theoretical economics may suggest that they do, but theoretical economics shouldn't penalize them for this, in fact, real world behavior.
Yeah, I think that's right. I think it can certainly be the case that concentration is important, and there are certainly cases, where we think that labor market where concentration on the employer side is playing a meaningful role in reducing wages. But there's in a search and matching sort of context, there are so many other factors that can be at play. So, for example, if a lot of people, they get their healthcare through their job. And so one of the reasons that they may be locked into a particular employer or locked into a particular place is because of healthcare. And so you wouldn't think of healthcare as necessarily something that promotes, that necessarily raises wages. But to the extent that access to healthcare allows people to more easily move across places or perhaps start their own business, that's a way in which worker bargaining power can be enhanced. And so I think there's through an economic lens, you get a very sort of complex picture of all the different factors that go into people's decisions about what types of jobs to take and where to take those jobs. And that impacts the relationship between what they're earning and what they produce.
And I know from firsthand experience, people who, prior to the passage of the Affordable Care Act, had said to me, look, I'd love to quit, but I can't because now I have a pre-existing medical condition and I might not be able to get covered at my next job. Neil, there's a quote in the report that really jumped out at me. While some job frictions can arise naturally, employers can take steps to increase job frictions or create new ones. Can you tell us a little bit more about that?
So exactly as you said, there's a lot of avenues through which firms can try and add frictions to the process of searching and finding new jobs. Non-compete agreements are one that we've already mentioned. Non-solicitation agreements where an employee can't leave and necessarily easily start their own business. Agreements where they have to repay some cost of training that they receive as part of their job. And non-disclosure agreements can be formulated in particularly broad ways to make them, similar in effect to some types of non-compete agreements. There's no poach agreements where you agree not to, again, go out on your own and hire other current employees. And then, things like mandatory arbitration also can function as a way in which at least you can not necessarily find redress for issues that you may have at the workplace. So I think these are all examples of different restrictive employment agreements that are designed to limit worker bargaining power and workers' ability to search and earn a wage that's commensurate to what they're producing.
Have you considered non-disparagement clauses?
I mean, I think that non-disparagement clauses are also a potential way in which you limit informational sharing. So if workers cannot, talk about about workplace conditions, if they cannot discuss, their previous employment situations with other workers, then that's going to inhibit the degree of informational sharing, and that works to the detriment of workers relative to firms. So, I mean, information, I think, is a huge part of realistically why the firm and worker are meeting on a unbalanced playing field. And I think there's an increased interest, at least within among labor economists, to study these types of frictions and figure out how important they are. But I think that anybody who spends a little bit of time thinking about it realizes that that type of informational imbalance is important, and these types of agreements, non-disclosure or non-disparagement, inhibit that type of informational, information diffusion.
So in the recent discussion about making non-compete clauses unenforceable for low and middle income workers, everyone pointed to the Jimmy John example, saying, hey, why are you preventing someone who's making sandwiches from going and working for a competing franchise? And everyone was getting mad at Jimmy John's and tweeting at Jimmy John's. But looking at that, there is just some boilerplate legal languages that sort of accretes onto contracts, because when you're in the legal department of a company, you never get rewarded for simplifying or taking stuff out of a contract. Your whole reward system is to just put in as much stuff as possible. That's why these click-through agreements are like 98 and 100 pages. In the securities context, you have concepts like a fiduciary duty. What do you think about like a duty to create the least restrictive employment agreement?
I mean, it's a good question. I'm an economist and not a lawyer, so it's hard for me to know how to balance those sort of considerations. But from an economist standpoint, I think you would want to ideally get to a place where the burden on the worker is as minimal as it sort of needs to be, to again allow workers to not have to piece through very complex legal agreements, particularly for jobs and for middle class or working class jobs, where it's important for workers to be able to switch and to be able to have mobility. So I think that from an economic standpoint, we want to try and minimize these types of impediments to worker mobility.
One of the things that came out of the Obama administration as a result of this, examination of labor market competition was the new guidance on no poach agreements and looking at them as presumptively criminal because they were considered wage theft and a form of price fixing. But there are other ways that employees might be harmed. And I thought one of the interesting things that was examined in the report was benchmarking studies and how those might weaken employee bargaining power. During our discussions with then Vice President Biden's office, an idea that was floated at the time was, what about if you have these aggregated benchmarking studies, what about disclosing that information to the labor side? What do you think about that as a way of increasing bargaining power?
Yeah, so the report talks a little bit about wage transparency and some efforts that I think different states have made with respect to trying to boost wage transparency. And I think that what you see is that efforts at wage transparency can, for example, reduce or eliminate the gender wage gap. And you find that in occupations where there's more wage transparency, there's more switching activity, and workers are also, just they're operating in a better sort of informational environment. It does have trade-offs because, there's some evidence, for example, that workers are less happy when they know what everybody else is making. And there's some concern that if you have greater wage transparency, then that's a way in which wages could be reduced instead of increased. So I think it's an idea that merits greater study, and my sense again not being somebody who's an expert in this, is that greater information is an important part of the puzzle here, and that if workers have a better sense of what the playing field looks like, they'll be in a better position to make sure that they get paid what they produce.
The report talks about ex ante versus ex post bargaining ability, and I think even in New York, I think the state of New York is going to require salary information to be posted in certain types of job listings. I come from a background primarily on Capitol Hill where our salaries were public information. And but at the same time, as anyone who's been following the Dear White Staffers blog knows, that alone wasn't sufficient to remedy some of the employer-employee imbalances. So it might be a piece, but I think, as you said, there are other factors there that also need to be considered. Neil, talk about the implications of the findings of this report for women, minorities, income inequality. How is this affecting the broader economy and the workers?
Well, I think it's definitely the case that a lot of the imbalance in bargaining power between firms and workers falls at the lower end of the wage distribution that disproportionately impacts women, disproportionately impacts people of color, workers of color. So I think that we've seen a big rise in income inequality over the last 30, 40 years. There are many causes behind increasing inequality, a declining share of income that goes to workers, and over that same period of time, at least prior to the pandemic, we were also in a period of pretty slow growth. And I think there are reasons to think that declines or low levels of labor market power, labor market competition are an exacerbating factor to higher inequality, to increased wage disparities, and to slower growth. So the report does, try and detail some of those connections, how the insufficient sort of labor market competition can spill over to broader parts of the economy, can lead to less investment, less mobility of workers, less productivity growth. Those are important macro trends that we've seen over time. There are many factors that are contributing to those trends, but I think that labor market competition is part of that story.
So Neil, what is next for the Treasury Department in this area? Are you going to continue investigating these issues, issue more reports? What's up?
Well, certainly Treasury is continuing to, study issues in the labor market. We're working on, thinking about the implications of unions and the decline in unionization on incomes. That's one task that we're looking at. When it comes to sort of the administration's actions with respect to improving labor market competition, those are largely in the province of the Department of Justice and the FTC and the Department of Labor. And they've, the administration has put forward legislation or is behind legislation in Congress that we think would make meaningful gains in improving worker bargaining power and improving unionization. So we hope that Congress takes a look and considers some of that legislation.
Well, that's all been extremely interesting. Thank you, Anant, for an excellent interview. I really do commend the report to all of our listeners, and you can access it through the episode webpage, or I imagine find it on the Treasury Department's webpage. Is that right, Neil?
Yes, absolutely.
Very good. I know you worked very hard on that. And now, as your reward, we're going to turn to something that we do with all of our guests to try to get to know them a little bit better as people. So the first question we ask is, tell us something interesting about yourself that's outside of your professional life.
Well, it's a good question. I'm a cyclist. So I like to go cycling. And one thing that I did kind of on a whim after completing grad school was bike across the United States.
Neil, you have an amazing background. You have a degree in economics from Princeton, a PhD from Columbia. You were a junior scholar at the Federal Reserve Bank of Minneapolis and a senior economist at the Federal Reserve Bank of New York. And you, like me, are also Desi. Does your family still think there's time for you to go to med school?
Yeah, they were definitely curious about it. I don't think they had any objection to doing to doing economics in undergrad, but there were questions about what are you going to do with this PhD in economics? So they're definitely probing questions about that. But I've always had a very supportive family and very open-minded, so they were okay with me not being a doctor.
And now, heading to the final segment of our show, we're going to play a little game we call The Curious Hat.
And now it's time for The Curious Hat!
The rules of the game could not be any simpler. Neil, would you kindly choose a number between 1 and 10, and we will select the question that corresponds to that number.
Okay. Number 3.
Number 3.
Number 3.
Anant, please deliver the question.
Number 3. Neil, you have a PhD in economics. Here's question number 3. If you're at a group dinner, you're not drinking wine, and someone decides, hey, I'm just going to order a few bottles for the table, even though clearly not everyone is going to drink, how do you divide the bill?
I think I would still divide the bill evenly. I try not to bring my economist hat into everything. And so while I might mentally make a note of the imbalance, I try to be that person who doesn't make a fuss over things. So I think people have enough reasons for not liking economists. So I try to avoid giving them more reasons.
Good. So you're a fun dinner companion. Much appreciated. Thank you so much for being on our show. It's been a wonderful dialogue with you. I hope listeners will join us next week.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.